In this lecture, we will be focusing on the different positions taken in traditional Islamic law with regards to religious minorities. We will explore this area by looking at two concepts, the concept of jizya and the concept of dhimmi. Jizya is a form of tax, and dhimmi refers to a non-Muslim citizen of a Muslim state historically. We are trying to understand some of the debates around these in the past. The past debates have some relevance to contemporary debates among Muslims on areas like citizenship and the rights of non-Muslim minorities in Muslim states today. Before we do that, let us have a quick look at Islamic law or traditional Islamic law. Islamic law is based on the Qur'an, which is the holy scripture of Muslims, and the traditions of Prophet Muhammad, otherwise known as Sunnah. In the Quran, we can find instructions or guidance provided to Muslims in the form of commands and prohibitions. For example, commands addressing dietary laws or marriage or inheritance. The traditions of the Prophet elaborate what the Quran says and often provide details or specifics. For example, when Muslims are instructed to perform daily prayers in the Quran, it was the Prophet who showed how the prayers should be performed and how often. Both of these sources, that is the Quran and the traditions of the Prophet, are considered the primary sources of Islamic law. However, as the Quran is not strictly speaking a legal text and does not address every single situation Muslims found themselves in over time, and similarly the Sunnah, jurists developed other tools for expanding and applying the commands and instructions of the Quran and the traditions of the Prophet. One of these was ijma, which is an Arabic word meaning consensus of Islamic scholars on a particular legal issue. It is a kind of universal agreement among Muslim scholars on a particular issue, which is mostly legal. Another was analogical reasoning, or in Arabic, qiyas. Qiyas is a very useful tool in Islamic law. It builds on precedent. If a ruling is given in the Quran or in the traditions of the Prophet on a particular issue, say, for example, prohibition of consumption of wine or alcohol, jurists can extend that ruling to other similar cases. For example, the prohibition related to consumption of wine can be extended to certain types of drugs people use today. Because of the similarity of the effect of consumption of alcohol or wine on one's mind and that of consumption of a particular drug. The focus is on the similarity between the two. Sometimes what is referred to as custom or how people have been used to doing certain things in a given community was also used to decide legal rulings. So these different tools were used to expand the norms, values, and commands of the Quran and the traditions of the Prophet. In fact, the vast majority of rules, regulations, etc., found in the traditional Islamic law or legal texts would be based on concepts such as qiyas, which is analogical reasoning. Over time, different schools of law in Islam developed in different Muslim communities. Each school was based around the teaching and the thinking of a particular well-known Muslim jurist. The four most well-known legal schools for Sunni Muslims are the Shafi'is, the Malikis, the Hanafis, and the Hanbalis. The Ja'fari school is the most well-known Shia school of law. So very briefly, when people talk about Islamic law or traditional Islamic law today, they are often referring to the rulings which jurists developed during the early centuries of Islamic history. These rulings are often referred to as classical or traditional Islamic law. Of course, Islamic law has been developing over many centuries. and the process continues even today. But why do we need to consider the role of Islamic law today, particularly with respect to treatment of the religious other? Well, there are a couple of reasons why this is important. First, classical Islamic law or traditional Islamic law remains influential in many parts of the Muslim world today. Many Muslim majority countries still apply some elements of classical Islamic law in their legal systems, along with modern laws taken from other legal systems, such as European law. So this makes discussions on Islamic law relevant today, especially when it comes to the debates on the rights of religious minorities in Muslim states. This is despite the fact that most Muslim majority countries have developed new laws about equal citizenship for all citizens and replaced traditional Islamic legal concepts such as jizya and dhimmi, which are the focus of this lecture. Another reason is that classical Islamic law is sometimes used by various Islamic groups or movements today to justify their ideologies or actions. You might recall that the group known as ISIS, or the Islamic State of Iraq and Syria, tried to establish a so-called caliphate in parts of Syria and Iraq. They used different elements of classical Islamic law, such as the rules related to jizya and dhimmis, to justify the treatment of religious minorities in the territories under their control. So the influence of classical Islamic law remains. Let us now look at the conceptions of Islamic and non-Islamic territories in the past. We will be looking at three terms: Dar al-Islam, Dar al-Kufr, Dar al-Harb. In our discussion on zimmis and jizya, it is important to know something about how Muslims in the past thought about how the world was divided from an Islamic perspective. You probably would have heard of terms like Dar al-Islam, Dar al-Kufr, or Dar al-Harb in discussions in contemporary Islamic political thought. Well, what do they mean? The term Dar, which is an Arabic term, refers to territory or land, or it can mean house also. So Dar al-Islam in general is the territory where Islam was dominant and Islamic law was applied and a Muslim ruler was in charge. So that's the most common understanding. Of course, there are other understandings. Dar al-Kufr is the territory where religions other than Islam were dominant and Islamic law was not applied. Dar al-Harb is the territory in which religions other than Islam were dominant and was actually or potentially at war with the Muslim state. There are, of course, other ways of understanding these terms, but what I have provided here is probably the most common way in which these terms are understood. This is, of course, a way of looking at the world in pre-modern times, in earlier times. In contemporary Islamic discussions on political issues, one can still find sometimes the use of these terms. Therefore, it is good to get some sense of what these terms mean. Perhaps the most commonly used terms among these is Dar al-Islam. This is often discussed today in relation to Muslim minorities living in non-Muslim majority states such as Australia or Singapore. The question often asked is whether these Muslims are living in an Islamically acceptable political and legal context. Many might even ask, are these Muslims in minority contexts living in a Dar al-Islam? There are a lot of debates around this issue, but let me summarize. Even in early Muslim juristic debates, centuries back, there was no agreement on the definition of Dar al-Islam, or territory of Islam. Some Muslim jurists argued that Dar al-Islam should be where a Muslim ruler is in charge and Islamic law is implemented. Other jurists believed that it is a territory in which a Muslim is able to practice his or her religion freely and where there is a system of law that is fair and just, regardless of whether that territory is ruled by a Muslim or whether Islamic law is in place there. What this means is that today countries in which Muslims live as minorities, where there is guaranteed freedom of belief and religion, and where there is a legal system that is fair and just to all, they should be considered territories of Islam or Dar al-Islam, according to some classical Muslim jurists and even according to some Muslim scholars today. Let us now look at the treatment of non-Muslims under Muslim rule in the past. The status and treatment of non-Muslims under Muslim rule has been a preoccupation of Islamic law and practice from the time of Prophet Muhammad. So this has a long history. In the wake of the death of Prophet Muhammad and under the leadership of the different Rashidun caliphs, more formalized discussions around the status of non-Muslims under Muslim rule began to form. This discussion centered on the notion of the dhimmi and the jizya tax. In this lecture, we will be looking at these two concepts very briefly. But before we flesh out these two conceptions, let us briefly survey some of the different legal categories associated with non-Muslims in a Muslim state historically. So we will look at three categories of non-Muslims and residency in Muslim territories. The categories are dhimmi, musta'min, and harbi. The term dhimmi refers to non-Muslim citizens living in a Muslim state. It was a legal arrangement that was permanent and intergenerational. Another category was that of musta'min. This referred to non-Muslim foreigners who visit the Muslim state and are granted a short-term safe conduct contract. In today's language, this would translate into a work permit, visitor visa, or other visiting permissions granted to foreigners. This safe conduct contract covers the visitor's right to security for himself or for herself and his or her property, and the visitor's obligations to respect and uphold the law of the land. The third category we are looking at is that of harbis. Harbis were non-Muslims who had no contractual relationship with the Muslim state. The term harbi is derived from the word harb, which means war. But this only suggests that non-Muslims who fall under this category might be at war with the Muslim state. Importantly, the term harbi is not intended to classify individuals without such a contract as an enemy of Islam or the Muslim state. It is simply a legal category. Our focus is on the governance of a pluralistic society, that is, of Muslim and non-Muslim permanent residents or citizens of a Muslim state. In the past, we need to get a good sense of what the category of dhimmi is all about in this context. As I have indicated, a dhimmi is a term historically used to refer to a non-Muslim living under Islamic rule in a Muslim state. But to be classified as a dhimmi means more than this. Dhimmi status infers that a particular kind of contract has been taken out between that non-Muslim individual or group with the Muslim state. A dhimmi contract is a legal document. It's a legal arrangement. It's a contract and not just a moral compact. This means that it is a legally enforceable agreement. A key aspect of this dhimmi agreement is a form of tax called jizya in Arabic. A dhimmi is required to pay the jizya tax. So the jizya is a tax paid by a non-Muslim citizen or permanent resident in a Muslim state in the past in return for the security provided by the state. The term jizya is actually found in the Qur'an, chapter 9, verse 29. But it also has a longer history. The institution of jizya existed long before Islam and existed in other empires at the time and even later. In Islam, the jizya reaches back to the time of the Prophet Muhammad. At this time, the Prophet accepted the jizya tax from the Jews and Christians, who are often referred to in Islamic tradition as the people of the book. The question for us is, who should pay the jizya? Some Muslim jurists argued that jizya could be accepted only from the people of the book, that is, the Jews and Christians primarily. Other jurists argued that it could be accepted from the polytheists as well. Still others suggested it could be accepted from all non-Muslims, regardless of their religious tradition. And in fact, what happened in Islamic history is that Muslim states treated all non-Muslim citizens as dhimmis, and jizya was accepted from all of them. So, as I mentioned, the jizya was imposed as a tax that was closely connected to the obligations of non-Muslim citizens and the obligations of the state towards those citizens in terms of providing safety and security and other relevant opportunities for them. The jizya tax was imposed primarily on men. Women and children were often exempted, as were old men, the sick, the poor, and the monks, for example. The tax was to be paid once a year, and exactly how much it would be was determined on the basis of the financial position of the dhimmi. In other words, the jizya tax was not meant to be exploitative. On this point, there is a report attributed to Prophet Muhammad in which he said, "Whoever oppresses a non-Muslim subject or taxes him beyond his capacity, I shall be plaintiff against him on the doomsday or the last day." In terms of how much this jizya tax one should pay, according to one view, a wealthy man should pay 48 dirhams per year. A moderately wealthy man would pay 24 dirhams per year, and a poor man, someone who is not that well off, would pay 12 dirhams. A dirham is a unit of currency in early Islamic times. According to another view, the minimum rate of jizya was 1 gold dinar with no maximum limit. Again, dinar was a unit of currency. Another view suggested that the ruler should set the rate according to what he believed was appropriate for the dhimmis. So there was no fixed amount as such, and Muslim states had different practices in relation to the rate of jizya. So what was the jizya for? Some Muslim scholars in the past considered the jizya as some kind of punishment for the dhimmis' unbelief or lack of faith in Islam, or perhaps as a form of humiliation for non-Muslims based on one reading or interpretation of in the Quran chapter 9 verse 29, which says, "Till they pay the jizya and agree to submit." Because of this reference to submission, jizya was understood to be as a kind of humiliation for the dhimmis. I would say that some Muslim scholars in the past and present have taken this phrase of the Quran too literally and have not necessarily considered its historical context. It is easier to suggest that the jizya was more closely connected to the safety and security the state provided to its non-Muslim members or citizens. In early Islam, there were times when the Muslim state could not provide this protection and security, and the ruler simply returned the jizya tax to the people, which suggests that the jizya was for this security and protection provided by the state. Some scholars say that the jizya was in lieu of military service, as non-Muslims were exempt from this service, at least in theory, in a Muslim state in the past. In practice, non-Muslims served in the military often. Others suggest that it was equivalent to the zakat that the Muslims paid to look after the poor and needy. At least there is that similarity. A close study of the early history of jizya shows that it was a tax that was meant to symbolize and actualize non-Muslims' allegiance to the political authority of Islam or Muslims, but not to discriminate against them. Jizya was not an invention of Muslims or Islam, In fact, this kind of tax existed in other states and other empires at the time. For example, in the Sassanid Empire, subjects, except the aristocracy, had to pay a poll tax according to their wealth. Was the jizya similar to zakat, which Muslims paid to the state? Well, some argue that in the time of the Prophet Muhammad, for example, the terms offered by the Muslim states to Muslims and non-Muslims alike were quite similar. Non-Muslims were expected to pay the jizya tax, and Muslims were expected to pay the zakat, which is approximately 2.5% of one's annual savings or earnings. In fact, the amount of Muslims were supposed to pay as zakat could be a lot higher than the jizya tax, which often tended to be fixed and relatively modest compared to zakat. Both Muslim citizens and non-Muslim citizens were expected to contribute to the management of the society and the state. Of course, Muslims do not refer to zakat as a tax, but for our purposes, the payment to the state by the Muslim is very similar to a form of tax. Zakat is one of the 5 pillars of Islam as well, and zakat is supposed to purify one's wealth. It is an obligatory payment, it is not charity. Let us look at the meaning of protection in a dhimmi contract. What are the details of this protection or protective contract? Surely there must be rules and regulations that non-Muslim citizens or dhimmis must abide by. The idea is that the payment of jizya ensures that the dhimmi is permitted to reside peacefully within a Muslim territory, and importantly, allowed to preserve his or her faith commitments and practice of their religion. We could put it more simply and say that the dhimmi is protected from religious or any other form of persecution or coercion and any internal or external threats to his or her person, property, or religion. But of course, it is a bit more detailed than this. The contract of protection, or what is in Arabic called aqd al-dhimma or aqd al-dhimma, is governed by a set of rules, which in earlier times were called the dhimmi rules. So these dhimmi rules and regulations outline the terms under which the dhimmi lives in the Muslim state, and the degree to which his or her religious difference will be accommodated or not. In other words, alongside paying the jizya, the dhimmi has a number of rules that he or she must abide by in return for state protection. A question for us is that does dhimmi status grant non-Muslims the same freedoms as Muslims or same rights as Muslims? In theory, individuals and communities classified as dhimmi owe roughly the same duties and enjoy roughly the same rights as Muslims living under Islamic rule. So this means that in many ways the distinction between Muslims and non-Muslims is legally irrelevant, at least as far as protection of one's person, property, and religion are concerned. The state is required to protect these for Muslims and non-Muslims. All residents or citizens of the Muslim state are entitled to and protected under the principle of equal treatment. For example, the criminal justice rights of a fair trial and other rights cannot be denied on the basis of religion or difference of religion. However, there are a number of exceptions to the principle of equal treatment. While the non-Muslim who takes the status of dhimmi assumes that his or her religious identity is respected and protected, the dhimmi is also required to show some degree of respect to a number of things that are primarily associated with the religion of Islam or Islamic symbols. There are 2 types of rules that are relevant to a dhimmi contract, according to classical Muslim jurists. Let us call these type A and type B rules. So 2 types. The first, which is type A rules, specified that non-Muslims were expected to meet certain requirements, whether these rules were stated in the dhimmi contract or not. meaning that whether they were written down in the contract or not. These rules are more about the need for the non-Muslim citizen to show some degree of respect to Islam and not denigrate it or its most important symbols. So at least remain neutral, that the non-Muslim should not say anything that is awful. These rules also include the idea that non-Muslims should not try to convert Muslims to their religion and should not provide support to external enemies of the Muslim state. If the non-Muslim citizen violates these rules, it means they are breaking the Zimma agreement with the Muslim state, and therefore they lose protection of the state. Now, just to emphasize these type A rules, let me give some examples of the type A rules. For example, the non-Muslim citizen should not say anything bad about the Qur'an and should not claim that the Qur'an is distorted. The Quran is obviously a very important symbol for Muslims. That they should not accuse the Prophet Muhammad of being a liar and that they should not insult him. That they should not make statements saying that Islam is a false religion. That they should not try to convert Muslims to their religion, and that they should not provide material support to the enemies of the Muslim state. There are, of course, a number of others, but these give a sense of what these rules are like. The second type of rules, which are type B rules, are not as important as type A rules. If a Dhimmi violates these rules, the Dhimmi contract still remains valid. Let me give some examples of these type B rules. Of course, this was in the past. Wearing distinctive clothing by the Dhimmis to show who they are. Well, wearing certain types of clothing in the past function like identity cards, as we used. The type of clothes shows what your religion is, for example, in some societies in the past. Another example is that the Zimmis should not build buildings higher than those of Muslims, or sounds like church bells should not be heard in predominantly Muslim neighborhoods, or the Zimmis should not display crosses or idols or pigs or actions of drinking wine in predominantly Muslim areas. So non-Muslim individuals and communities residing in Muslim states were obligated to show some degree of respect to the symbols of Islam, at least that they should not insult Islam and say awful things about symbols of Islam. This obligation did not mean embracing the Islamic belief system. Non-Muslims were not under any obligation to believe that the Quran is the word of God, or that Prophet Muhammad is the last prophet of God, or anything like that. Such an obligation would negate the Islamic principle of non-compulsion in matters of faith, which we have discussed in earlier lectures. So what does the obligation to respect Islam mean then? Most simply, it means that non-Muslims living under Muslim rule must not, by their words or deeds, insult the Prophet or show disrespect to the Quran and key symbols of the religion. Again, if you look at this requirement, Muslims are also required to show respect for Islam and should not denigrate Islam and its key symbols. If a Muslim does that, again, the Muslim loses the protection of the state to a large extent. This is a different debate, and we'll have some discussion about that in another lecture. Let us look at a couple of examples of limits to this protection. First, we'll look at the right to build or renovate places of worship. This can be a controversial issue of whether Zimmis are allowed to build new places of worship, particularly in the areas where Muslims form a majority. There are a number of views in traditional Islamic law or classical Islamic law in relation to building or renovating places of worship for Zimmis, such as the churches and synagogues within the Muslim state. One view is that there should be significant restrictions on building new places of worship and also in renovating existing ones. Obviously, such restrictions will be a significant problem for the Zimmis or for the non-Muslim citizens. This will be a significant restriction on their freedom of religion. The other view is that historically Muslim states have always allowed building of new places of worship and renovating existing ones without too many restrictions, and that this should be the norm. This view supports the idea that the Muslim state should not prevent its non-Muslim citizens from freely practicing their religion, which includes building places of worship or maintaining places of worship or renovating. Those who support this view would argue that even during the earliest Muslim state and in subsequent periods, Muslim states allowed their non-Muslim citizens to continue building places of worship. A good example is Baghdad, which was a newly created city at the height of the Abbasid Caliphate. Baghdad was home to great Muslim theologians and jurists, and a city of an overwhelming Muslim majority. But it seems scholars did not call the practice of building churches and synagogues into question. Let us look at another example of the limits to this protection. We will look at the rules around the consumption of alcohol and pig meat, such as pork. Well, consumption of alcohol or wine is forbidden by Islamic law for Muslims. Similarly, consumption of pig meat, such as pork, is prohibited for Muslims. Do you think dhimmis would be required to abide by these same laws? Well, interestingly, classical jurists allowed dhimmis to consume those things freely. They could consume alcohol or wine, they could eat pig meat, such as pork, if they so choose or chose. A number of Muslim jurists argued that the main principle behind the Dhimmi contract is to respect the non-Muslims' religion and their traditions. If then the consumption of alcohol, or wine, or pork was practiced in a Dhimmi's tradition, then it would be counter to the contract of respect and protection if they were then prohibited from doing so. However, as much as some jurists permitted Dhimmis some freedoms that Muslims were not allowed, ultimately the best interest of the Muslim majority was always quite important. In relation to the consumption of alcohol, for example, while jurists allowed Dhimmis to drink, they were concerned that such practice might harm the Islamic status of the broader community. Some jurists were concerned that unrestricted alcohol consumption might endanger what they referred to as the social good. And so they developed legal rules that restricted their consumption in a number of ways. For example, banning public drunkenness or public displays of alcohol, while allowing non-Muslims to consume them. Does that example begin to show the juggling act that governing a pluralistic society might entail? Can you identify what some of the basic principles might be that they are drawing on? Well, in the last example, I think what is most obvious is that the jurists were developing a notion of the public good in relation to the Islamic character of the state. They were trying to accommodate Dhimmis as best as they could, but this accommodation must not conflict too much with the general Islamic character or ethos of the society. So we could say that the jurists at this time invoked public policy concerns to address the challenge of governing with a pluralistic ethic. So in this lecture, I have tried to provide an overview of the ways in which classical Muslim scholars have approached ideas around the governing of non-Muslims in a Muslim state, or in other words, managing a plural society. We looked at the notions of dhimmi and jizya and explored a number of debates held in relation to these key terms. What these debates reveal the most probably is the seriousness with which the treatment of non-Muslim citizens or residents in Muslim states in the past was considered. Obviously, these debates were most relevant to management of these plural societies in the past. Given that there are still debates among Muslims around these issues, even in the context of modern nation states, it is important to get a sense of how these debates functioned in the past. A key question for all the jurists concerned was how to preserve the Islamic way of life for the good of the majority, that is the Muslim majority. But the accommodation of the dhimmi was also deemed important and crucial. I hope this lecture has given you some insights into the complexities of governing pluralistically, but also its possibility. Thanks for watching. We hope this deepened your understanding of Islam. Be sure to check out the other videos in this series. Keep exploring. Don't forget to subscribe.